From AIT Studios in Abuja, Nigeria, this is the O&M Sunday Show with Obiora Ilo and Mamode Akuga.
Hello there. It's another Sunday, and it's time for your show, the O&M Sunday Show. I am Obiora Ilo, and it's on a Sunday that is a little rainy in Abuja. I understand it's raining in a lot of places, some parts of Southeast, some parts of Southwest, but it's a little rainy in Abuja this afternoon, and it's also on a day that so much is happening. I don't know if you followed the developments in the United States, the white policemen being accused of targeted violence at blacks. Of course, in quick succession, just 2 nights apart, we had 2 blacks murdered, some say in cold blood, by law enforcement officers in the United States. And then we call this retaliation. About a day or 2 later in Atlanta, a black American killed 5 policemen and wounded about 7. And until he was, blown to pieces by a robot, he was still threatening to kill more white policemen. And when things like this happen in so-called advanced countries like the United States, you will start wondering what is going on. And I remember that I was just talking with a friend of mine who just came back from the United States, and he suggested that some of us in Nigeria even have more human rights than them in the United States. Well, sometimes you get it right, sometimes you get it wrong, but that's the United States. Back home in Nigeria, I think the stories that have been trending since last week are still trending. Of course, we still have the arguments and counter-arguments about whether Saraki and Ekweremadu should have been brought to court, should have been charged to court, whether that was a violation of the independence of the arms of government. That argument continued all through last week and is coming into this new week. We also have the drama in Abia still going on. With all this happening, sometimes I start wondering whether Nigerian judiciary is something different from what you have all over the world. They say courts of, let me use my layman's language, courts of equal jurisdiction giving counter orders, and it's like Animal Farm. Some people say some of those judgments are bought. I don't have any evidence. Some people say people just procure them. I don't have any evidence, but that's what we are hearing. But when you see these judgments coming from left and right, some people will get it from a village court, some will get from a state court, some will get from a federal court. And I hear some people are even trying to get from ECOWAS court, I don't know what's going on. Is it that something is wrong with our judiciary, or is it that something is wrong with us Nigerians? Because I'm sure if Nigerians don't approach the judiciary to come with these funny judgments and rulings and motions, maybe they won't be doing it. Just like they say, every society gets the leaders it deserves. I think also every society gets the judiciary it deserves, So all that is still happening. But something I want to talk about this afternoon is not about the judiciary, neither is it about the legislature, the one I want to talk about right now. I want to talk about one of the most popular, most vibrant transport corporations, private transport corporations in the Southeast. It is called Peace Mass Transit. And I'm wondering whether the FRSC, those that take care of the roads, whether they see the accidents that we have every day involving drivers and vehicles of Peace Mass Transit. Is there no laws that can restrict them or make them do the right thing? Every day on our roads is one carnage after another. Peace Mass Transit. And you're wondering whether that is just a lawless company or the drivers are just lawless. I'm just saying that something has to be done. This is a country, and we are talking about Boko Haram, we are talking about armed robbers, we are talking about kidnappers. But how about a transport company that is taking the lives of tens and tens and tens of people on a daily basis and nothing is being done? It's my business. Nobody is going to say it's not my business. It's my business because anything can happen. I'm calling on those that should know. I'm calling on the management of that company to get their act right. And if they can't get their act right, then those that are charged with making sure that the proper things are done on our roads should step in. That aside, let's talk about today. Today we are looking again at the propriety of arraigning the Senate President and the Deputy Senate President. I understand that tomorrow at Justice Haliru's court at the Federal Capital, the High Court, the FCT High Court, that case is coming up again. But just a couple of days back, a judge says, I don't think this is right. That was a ruling. And like I said when we started, you hear these arguments and counter-arguments. Well, everyone is talking about it. So what did we do? We've brought back those that should know. I have in the studio Honorable Ngozika Ihuoma, who is Executive Secretary, Legislative Watch. He's already seated. I also have a lawyer, Abdullahi Isezua Rahman, a Senior Associate at Marble Partners. This afternoon, we are going to look at this issue. I also try to, pick their brains on what is happening in our judiciary. Whether these, courts doing what they like is constitutional. Maybe it is, I don't know, I'm not a lawyer. So they're already seated in the studio, and I'm glad you're part of the family this afternoon. So just sit back, and we take a break. When we come back, we talk about some of these things that are also agitating you. But before we do that, let me quickly acknowledge the various letters and text messages and emails we've been receiving from all over Nigeria. The very exciting thing is that people are not just commenting about what is happening in Nigeria, they're also suggesting to us some of the issues that we can discuss on this program. And today's discussion is actually part of some of the text messages we've been getting on this matter. If you're looking at your screen, we just wanted to take one that we found quite interesting. It's coming from Mina Kuremeima. He sent his text message from 07064010951. And he's weighing in on one of the issues we discussed on this program in the past 1 week. He's talking about the Niger Delta. So many messages, but we are sincerely sorry we can't, talk about all of them. But let me quickly also acknowledge that we got a message from Mrs. Aja Jebe, who is sending a message from 0833044988. We also got from Charles in Lagos. Charles sent his message using the phone number 08062780350. We also got from Uzigwe Leonard, who also called from Lagos on number 07063000087. A lot of the messages we can't put out because people send messages without their names, without their numbers, without where they are sending their message from. Would like you to give us all those details. When we can, while the program is going on, we'll talk about it. But when we can't, we'll acknowledge them both on air and in the messages we usually will send to thank you for your participation. So let's take this break. When we return, we'll be looking at what's going on with the arraignment of the Senate President and his deputy.
Are you watching Nigeria's biggest late night show?
I think the government is doing its best.
Buhari himself is an issue. Just as the Buhari organization has made Goodluck Jonathan an issue.
We have laws, we have institutions set up to fight corruption.
Advocacy for the Chief of Health is born out of what they symbolize.
The average Nigerian wants to know, what do you have for him?
Fani Kayode was with us for a while.
What happened?
I think he came on a journey and discovered that we were too transparent for him.
A banking license was cancelled in one day, and a license was cancelled.
Thanks, and glad to know you're still out there with us. And joining me right away is Honorable Ngozika Ihoma, Executive Secretary, Legislative Watch, and Abdullahi Isezua Rahman, Senior Associate at Marble Partners. Gentlemen, glad to have you.
Right on.
You're welcome.
It's good to be
You're welcome.
Here too. Thank you.
Well, you heard some of the things I said when we were starting. Let's even start from there. You know, I am not very versed in these things, but even as an ordinary person, I worry about Mr. A goes to a court in FCT, a federal high court. Mr. B goes to a magistrate court. Mr. C goes to a state high court, and stuff like that. Let me start with you. Is this normal? Is it proper? Is it constitutional? Is it legal?
Well, I will take it from political first because I will defer to a lawyer to take the
To do the rest.
I want to take the political angles today.
Yeah.
It is democratically right.
Democratically
Right.
right. Okay.
Yes. Any aggrieved person, by provisions of this constitution, instead of self-help, instead of taking up arms, you are asked to go to the judiciary, take a legal step. And let me again say that no two cases are the same. That is why every matter that is instituted will be heard by a judge. But can you continue to the end or any other? That's areas where we're going to look into now. Okay? So if you have an issue, I have an issue now with Vim Martin Ilo, I'll go to court. If my brother here has a matter with you, he'll approach the court. Even if the same matter is what is at stake, but we may look at it from different prisms. So everybody is allowed democratically to exercise that right.
To approach the court.
Yes, approach the court. Because that is only civilized and democratic way of doing things.
Okay, let me go to Abdullahi, who is a lawyer. Abdullahi, let me ask again. Is it legal? Is it proper? Is it constitutional? Is it normal that people can, in one matter, you go to A court, another one goes to B court, not that they are going to the appeal court? Please, can you educate us?
Well, thank you very much for having me. I would rather not say whether it is legal or illegal, because every matter depends on the fact of a case. For instance, we could have a scenario where something happened. I am aggrieved. I see myself as an aggrieved party. Just like his Honorable said, the proper thing for me to do is to approach a law court. The question is, if I approach court A, can I at the same time, from the same fact emanating from the same issue or issues emanating from the same fact, can I go to 2 or 3 separate courts? That is no. Because when you approach one court upon a certain grievance, you believe that that court you can ventilate your grievance there, and that court that has competent jurisdiction can adequately address the issue you have before it. So it will not be too proper to file the same case, issues emanating from the same fact. Maybe you decide to divide the issues into several issues. You take one before this, take the second one before this. The annoying part is where these courts are even court of coordinate jurisdictions.
I have to come back to you. Actually, you know, one is tempted to zero in on Abia because that's what's on right now.
Yes.
You know, Oga, the man that has gotten a certificate of return from INEC, approaches the Federal High Court in Abuja, and they say the governor in Abia shouldn't be governor, should vacate and all that. And the governor, instead of coming to the Federal
Court of Appeal,
going to Court of Appeal or High Court, goes to, no, he has done that eventually.
Yeah.
But I'm talking about the sequence.
Osisioma High Court.
Yeah, he goes to an Osisioma High Court. First of all, to ensure that this that the Oga group don't, you know, exercise whatever powers that been given them by this other court, and then goes to another Federal High Court. You know, stuff like that. That's, you know, can you situate, you know, this education on this scenario?
Well, what is happening in Abia State, we must say, is not an issue that one, as a legal practitioner, should be very comfortable with. Because we have to be very careful with issues so that we will not end up setting a very bad precedent. When a court of law has decided a matter, wrongly or rightly, the proper thing for any party who is not happy with that decision or who is not comfortable with that decision, the proper thing to do is to appeal to Court of Appeal, assuming the judgment is given by a state high court or a federal high court, in this case by a federal high court. What is expected of a sitting governor, the sitting governor is to go on appeal, and I know they said they have done that. The part that we are not too comfortable with is the fact that they have to approach a high court again to get another order that now seems to be countering the order decision of a federal high court, even though they are court of coordinate jurisdiction. The action of that high court, in my own opinion, is wrong. It's very wrong. What the court ought to have done in that situation is to throw out whatever is filed before it and tell them, in case they don't know what to do, tell them to approach the proper court, which is the Court of Appeal. So that we will not have this kind of scenario that we are having today, where two courts of coordinate jurisdiction having conflicting decisions over the same issue. So which should be enforced and which should not be enforced? And I think we have to be careful with our politicians, because they put the court in this situation, quagmire. Yes.
Okay, well, I won't come to you yet, Ngozi. Let me go back to Abdullahi. When we have this kind of confusion,
yes,
when we have this kind of what, I mean, if you open the papers, this is what you see, a lot of open-ended comments and features, you know, everybody's talking about it. When we have this kind of what someone in the papers called judicial rascality, in quotes, is there an authority that can do something? The NJC, the chief justice, or what? Who is supposed to come in at this point and, you know, set things right?
Well, in this kind of situation we find ourselves, the NJC you mentioned, the Nigerian Bar Association at the national level, these two bodies, of course, the CJN is part of the NJC, it's even the head of the NJC. I think they have to come together. They need to work together to forestall this kind of occurrence in the future. For instance, I am a lawyer. When you approach me to file a matter in a court, and I know, or I have reason to know, that that matter has already been done to finality by a court of competent jurisdiction, by my own calling, I should be able to advise you properly that no, Mr. Man, we cannot do that.
And this is what we can do.
This is what we can do instead. But where you find a situation that one way or the other, we just want to get what we want to get. So regardless of whether you need to protect the sanctity of your own profession, because in the eye of the public, how do people look at us?
Yes.
As lawyers. Because there's nothing happening if you don't read it on the pages of newspaper. In most of the media outlets feed us on what is happening in our society. The Abia issue is not a hidden issue. We know that it has been concluded by a federal high court. Then you now approach me as a lawyer and say, okay, or the same lawyer who appeared before that federal high court and did the matter from beginning to the end will be the same lawyer again to approach a high court or another court on the same issue.
I think we'll leave it there for now. Tomorrow at the Federal High Court, before Justice Aliru, the forgery case involving the Senate President and the Deputy Senate President will be heard again. I like it when you said, let me look at it from the political point of view.
Yes.
So much has been written. In short, this morning I was privileged to see the article or the position taken by Professor Nwabeze, Senior Advocate of Nigeria, where he argued so much about the sanctity of what's they call it again?
The three arms of government.
The three arms of government, their independence and all that.
Yeah.
But from your, your executive secretary of the Legislative Watch,
yes,
you know, you have some good idea about how the legislature works.
Yeah.
You're not a lawyer, though.
No.
Do they, like Professor Nwabeze argued, could what happened in that house, in the National Assembly, in the Senate, could it be described as internal affairs of the Senate?
Yeah, let's start by looking at one thing. If you look at the Constitution of Nigeria, and you look at Part 2, and which is powers of the Federal Republic of Nigeria, the powers are divided into three. In Section 4, talks about the legislative powers. It's given to the National Assembly, the State Assembly, and of course it gets to the councillors at the local government level. Section 5 talks about the executive powers. These are powers given to the president at the executive level. And Section 6 talks about the judicial powers, which is the one given to the judiciary, headed by the CJN. Now, I've tried to look at this because that's the foundation. We have a written constitution, and every action we take must be guided by this action, this document. Now, the National Assembly, as an arm of government of its own, has got its own constitutional provisions, what it's supposed to do. And Section 60 here is clear again. And what did this Section 60 talk about? It talked about the fact that subject to provisions of this Constitution, the Senate or the House of Representatives shall have power to regulate its own procedure, including procedure for summoning a recess of the House. If you look at this power given to the Senate or the House of Representatives by this Constitution, what is at stake today is the standing order, how they should run themselves internally. It did not go to how this Constitution should be run, but how do we operate? And they have operated within their powers since 1999. The making of the rules of the Senate or House of Reps is that of the Senate. If for any reason they disagree in anything they do, they have equally have mechanisms. This same Constitution have asked them to create committees. This Section 54 is clear about committees. And in those committees, there's the one that is called Rules and Business, and there's the one that is called Ethics and Privileges. If you venture to have gone contrary to the standing rules of the Senate, you are brought to that committee. And it is when they have dealt with you and felt that you have not infracted on this Constitution as a body, they cannot approach the executive arm. Well, that's where the police can be approached. It's the body of the Senate that will take that decision. That
not anybody
not
outside
anybody. Any member who takes that decision inside will have to report it to the committee, to their internal, and the majority decision will rule. The minority may have their shout. But whatever is the majority decision, as of today, the majority of the Senate have said that our rules
were not
violated. And to that extent, the executive must respect that institution that have said our rules are not.
Okay, Ngozi, I'm coming back to you, but let me ask Abdullahi. You know, I'm not versed in law, and I know that on the Tuesday 28th of June 2016, that His Lordship Justice G.O. Kolawole took a position. There was a ruling.
Yes.
I don't know if you're privy to this ruling. Can you break it down? What did he say? And again, it goes back to my first question about one court says this and the other court says that. You know, what is the implication of this ruling by Kolawole on the 28th of June?
Yes. I have been privileged to see the ruling of Justice Kolawole. And before we know the implication of that ruling, we need to know what the ruling is all about itself.
Okay.
Yes. It's a matter filed by a senator,
Gilbert
Inaji, against the AGF, Attorney General of the Federation, and the Inspector General of Police before the Federal High Court. They went by way of originating summons, accompanied it with motion on notice and motion ex parte. So, of course, motion ex parte, to them, there's an urgency that the court need to look into and decide on. Let me summarize what they were really after, what that suit was
about.
Yes, was about. It was that some few members of the Senate, or a member of the Senate, Honorable Suleiman Hunkwi, wrote a petition against the Senate to the police, alleging that the standing rules of the Senate 2015 is forged. Then the police went into investigation. Batinaji now filed this case, saying that no, whatever must have happened is our internal affairs. It is not something any other arm of government. Of course, we know that the police is part of the executive. And going by the doctrine of separation of power, the three arms of government are to act independently. But let us not lose sight of checks and balances. Now, he said, it's our internal affairs. Let us resolve whatever grievance we have internally, even if few among us decide to take our internal affairs to the public or to the executive arm, which is the police. You have to refer the matter back to us to resolve. So he needed the court to give an order that the report, whatever report the police will come up with, should not be acted upon by anybody, including the Attorney General of the Federation. So now, when that was done, the judge, Justice Kolawole, in his own wisdom, said no. Let us tarry a while. Let us have a situation where the AG and the IG will come and show cause why this order the plaintiff is seeking before this court will not be granted. And the matter was adjourned for them to show cause why it should not be granted. On the day the matter was to be heard, the day they were to show cause, the AGF filed an originating summons. Another application was as well filed. That application was now to join the man that wrote the petition against his colleagues, Honorable Suleiman Hunkwi, to be joined as a party. It will interest us to know that part of the lawyers that filed that motion is the current Attorney General of the Federation. But at that time was not yet appointed, the AG.
He was a legal advisor to APC or something.
No.
Yeah, well.
Outside that, he's a lawyer to Hunkuyi.
He's
one of the lawyers to Hunkuyi.
He's one of the lawyers of Hunkuyi.
The man that had petitioned the police.
That had petitioned the police.
Okay.
So, after that, meaning they did not file any affidavit to show cause why that order that the plaintiff is seeking should not be granted. And they equally filed some preliminary objection challenging the jurisdiction of the court, that the plaintiff don't have local standard. All those issues were before the court. The court said yes. The issue will be resolved one after the other, particularly the issue of the preliminary objections raised and the issue contained in the motion ex parte. But all parties, the court did not use the word that lawyers often confuse among themselves, or maybe intentionally or otherwise. The court did not say status quo be maintained, because the court was very conscious of that phrase. Whenever the court said maintain status quo, I interpret it to my own benefit, he interpreted to his own benefit. The court said no party should take any step that will affect the subject matter before the court. That was the case. The case is still pending. Just recently, the AGF, the Attorney General of the Federation, although has the power to so do, to institute criminal proceeding against anybody by virtue of Section 174 of the Constitution, he filed the charges against the Senate President, the Deputy, the former clerk, and all that. Yes. But the question is, knowing the pendency of this suit before the Federal High Court, why the rush to file this another case which has the same root with the matter before the Federal High Court? Whatever charge the AGF has preferred against the accused persons, the defendants in this case, emanated from the report of investigation by the police. That same issue of report that is currently before the Federal High Court since 2015.
So what did Kolawole say on the 28th?
What Kolawole said on the 28th is simple. Kolawole said, of course, he recognized the power of the AGF under Section 174, but at the same time, he did not lose sight of the provisions of Section 174 sub 3, which said, AGF, while exercising that power to prosecute or to institute a criminal matter, must take care of 3 factors. Must be wary of these 3 factors. Public interest, the interest of justice, and must ensure that the legal process is not abused. But Kolawole said, when you look at the action that has happened, that is, the filing of the charge against the defendant before the FCT High Court, Justice Halilu, it amounts to an abuse, using the constitutional word, the abuse of legal process. But the court said, what is the proper thing to do? Having said this, he cited some Supreme Court authorities that said the proper thing to do is to end that abuse of court judicial process there and then. But the court said he had to tarry a while in this circumstance, because the court that is already seized of the matter, the FCT High Court, is a court of coordinate jurisdiction with the Federal High Court. So, he will not be having the constitutional power to declare the proceeding before a sister court as null and void. But if that charge were to be filed before him, he would have so declared it to be null and void, as because same will be seen as an abuse of legal process. That was the ruling of Justice Kolawole.
Now, what is the implication of that?
The implication of it now is that the Attorney General of the Federation is the #1 law officer of the Federation. Whatever the power he has under the Constitution, it has to be exercised with caution, because whatever he does at the federal level is what the AG of the state will also do, and that may have a long-lasting effect. In my opinion, the proper thing to do at this stage, being the #1 chief law officer, is a prosecutor, not a persecutor. The proper thing is for him to make the High Court of FCT aware of this ruling of Justice Kolawole. Should be brought to his notice, not even by the counsel to the defendant. He, the AGF that filed the charge, should bring it to the notice of the High Court, so that, if possible, the High Court can stay action. Let that matter before the Federal High Court. Terminate, whichever way it goes. If the court say you have power to act on the report, this one can continue. If the court says otherwise, they'll have no other choice than to let it go.
Okay, you know, where a lot of pro-Ekweremadu, pro-Saraki, agitators, forgive me again.
Yes.
What they're holding on to is separation of powers, the independence of the legislature, judiciary, and the executive. And I've had arguments. Like I said, it's everywhere. Every paper you open, you see opinions and all that. Some people have said, since we are talking about this independence, if an incident happens in the National Assembly or in the floor of the House, one member shoots another. So we say because it took place within the chamber, nothing should be done. So the AGF, if the AGF notices that some laws have been broken, just because there's independence, then he does nothing about it.
Let me look at what we call the parliamentary immunity. And like he has said, this separation of power, this independence is not absolute. And if you look at inauguration,
if it's not absolute,
now,
if it's not absolute, so why are we worried about what is going on right now?
No, first of all is there's a procedure and there's a rule of law. And that's why I said initially that going to court for any reason other than self-help is right. And that is even why the constitution had equally captured where if there's abuse, like what we have looked at in section 174 sub 3, the AG, either at the state or federal, has power to look at when there's an abuse of court process, legal processes, to discontinue a matter. Now, in the parliament, there's what is called parliamentary immunity within their territory. But we equally know that those who are there are operating within a constitution. If, like you have said, a member, that's why in the parliament, you are searched. You are not allowed to bring in any offensive material because it's an aggregation of more than two people. We are talking about the president and the vice. There's a senior and a junior. But in the parliament, in the Senate, we are talking about 109 equal members. In the House of Reps, we are talking about 360 equal members. Okay, that's why caution is taken. You are not allowed to bring in your police. Within the National Assembly or any assembly, they have what they call the sergeant at arms. They have the internal security where everybody is freezed, including the senior president. Nobody comes in with any harmful, including your umbrella, including if you have to come with walking stick. They must make sure that that walking stick is guided properly so it doesn't become an arm. Now, what we look at is that when you abuse that privilege, that's where the institution of the Senate will come in. Like we are saying now, let us assume that there was a forgery of the rules of the Senate. And the Senate looked at it from both the executive session and the plenary and everything and agreed that some members or even the bureaucrats have forged their working document because that's the most important document. It is that document that enables them, they suspend the rules of that document to admit Mr. President or anybody to make presentation to them, before them. So it's a weighty document, all right? If it's forged for any reason, it is the institution of the Senate that will now look at it and report, because they don't have the coercive power. They don't have the judicial power. It lies with the other two arms of government. As reasonable as they are, it is within them to report it. If they say so, we will not report it. It is now a function of the conscience. It falls back to that which we have asked the AG to do. Can you look at this process you have taken now against the senior president and deputy senior president? Is it legal? Is it by your own conscience? More so when you were a lawyer, a counsel to one of the complainants. And he has not, there's no official document to show that he has withdrawn. Even as a sitting AG, the first thing would have been to file the processes to disqualify from that matter. But today, he has disobeyed the court, who said nobody should take any step while I'm hearing this matter. That matter is pending and is now in another case. Okay? So this issue of independence is not absolute. Mind you, it is the CJN that swears in Mr. President. That's from the judiciary. Okay? Then it is the president that appoints the CJN. Okay? Who will now be cleared by the Senate. You can see the synergy. And again, it is the president that now inaugurates. The powers exercised by the clerk on 9th of June was the powers of Mr. President, which Justice Kolawole had equally mentioned here. That these are powers of Mr. President that the clerk of National Assembly exercised. Under the National Assembly, it was the president that was supposed to walk into the chambers of National Assembly and sit down there and conduct that election. And I don't think that anybody would have been telling us today that Mr. President forged the rules from a villa and walked into the assembly to inaugurate. So these are issues like he has said, and that's why I decided to take the political angle of it, not legal today, to say that politicians, we have had only 17 years of unbroken democracy, but we must do things, leave it at the realm of law and order. That's where, when you talk about the issues in Abia, politicians interfere with judicial process in Abia. If not, a man who has gotten a judgment, Oga, had no reason to rush any judgment. Okay? Because this constitution have only provided here right of appeal, and that right cannot be waived. But we had an INEC who now said they filed an appeal without a stay. First of all, they said there was no appeal. Second day, they say, well, we received an appeal, but no stay. Only for the AG in Abia State to now show evidence of both stay and so that was where they started approaching an Osioma High Court. You can see the, but again, Nigerians should know that there was another ruling last Friday in Federal High Court of Owerri on the same matter, where this same organ now was a defendant. And I don't think he brought that issue to the Abuja Federal High Court. That this matter, he brought the same forgery issue.
No, it was Nwosu that brought the matter.
Nwosu sued him. He was a defendant in that matter. He was a defendant in that matter before, in Owerri. Okay? Nwosu instituted it.
And the judge in the Federal High Court said the facts before him.
Yes.
The facts
before him.
Yes. Said there was no forgery.
Yes. Why the one in Abuja now have said there's forgery? So
facts before him. Good. Too. So like you said, every case has its own peculiarity.
Yes. Yeah. Now that is where those who equally arrange our constitution under the judicial proceedings have set a ladder. You have the High Court, even you have the Magistrate Court, the Sharia, the lower courts. You have the High Court, you have the Appeal Court, you have the Supreme Court. And the beauty of it again is a High Court is manned by one judge. But at the appellate court, he need about minimum of three, to look at the same thing that one judge looked at. At the Supreme Court, you talk about minimum of 5 judges looking at the same matter that one High Court. So that will show you that the law protects everybody. Okay. So we politicians must learn to, because we have not had it more than 17.
But the politicians are not forcing the judges to take the actions they are taking.
No.
Is it not possible that somebody comes to court and the judge says, no, I can't handle this, you go back to so and so?
No, that is where the beauty of what Justice Kolawole had done. If it was in the other, using the word quote unquote rascality in the judicial process, Justice Kolawole last Friday could have said, based on the rulings, I have 2 of them here before now. He had given 2 rulings earlier, asking parties here to maintain the status quo, even though he didn't say it because of abuse, like my lady friend said. Okay? But he has said nobody should take any step that will make these sittings here now unnecessary. Okay. So, based on that, he refused to make any order. But he expects that his brother, George, by tomorrow, will be able to make that judge will be able to say, please, AG, do the proper thing. Get this matter off.
Let me go back to Abdullahi, because I'm not saying you didn't quite answer my question, but I want more light thrown on it. The independence of the 3 arms, I asked Ngozi, if a criminal offense is committed in the floor of the Senate, so nobody does anything until the Senate says, okay, the man shot him and we think that it was wrong for him to shoot him, then the police come. No, please, can you?
Yes.
Because a lot of people are saying that independence is not absolute.
Thank you very much. Truly, the independence we are talking about certainly will not cover a scenario that you have painted.
Okay.
For instance, where a member, as we often see it happen at the National Assembly and some state houses of assembly, one thing or the other cause problem on the floor of the house. You see some of them uprooting chairs to fight. If in the process an honorable member used anything or by any means hit another honorable member and that one just fell down and died, certainly the issue of independence of the legislature cannot be a cover to whatever must have happened, particularly coming to this very scenario you painted.
Okay.
That senator certainly will face the music in the court of law. But the issue...
Yeah, what's the difference between that and the matter we are talking about?
The issue we are talking about has to do with the House rules, the standing rules of the House. Whether a man used the word in your petition, you say it was forged, or otherwise, whatever it is, that particular issue is an internal affairs that ordinarily ought to be resolved internally. And even the man that wrote the petition, I have not seen where, because it's just a page petition, the one I saw. I didn't see anywhere he said, we attempted to resolve it internally and it failed, or the leadership of the Senate refused or frustrated the settlement or the resolution of the issue
of the matter
before he decided to write a petition to the police.
Okay. You know, there's the ethics and privileges.
Yes. Rules and business.
Rules and business. If this member has not explored these alternatives and has written to the police and bringing this inconvenience or discomfort to the hallowed chambers of the Senate, does the Senate not have a mechanism to either sanction him or to call him to order? Or, I mean, is it his right to just go ahead and do that?
First of all, the Senate, the 8th Assembly, came with a lot of what I have called divine intervention. From 1999 to 2015, the then PDP had what we call the two-thirds majority. They could sit down in Wadata Plaza and decide the fate of anybody. But that luxury, nature did not afford it, the APC. Both chambers of National Assembly, in the House of Reps, in the Senate, they never got two-thirds majority. To a large extent, they needed a lot of inter-party and intra-party collaboration. And it is an attempt not to rock the boat. Okay? Let us not forget the fact that because of this nature of having 49-60 members was what gave the PDP the opportunity to produce the Deputy Senate President, which today remains the focal, the most annoying part of the APC. That's why did the PDP share? But nature, it was nature that made it possible for them, because with 49 members, they can form a quorum, they can run the assembly, because they need only 33 members to run the Senate, and they have 49. If they were not, if they were greedy, on 9th of June 2015, they could have taken the Senate presidency, because we saw the APC members move over to the International Conference Center, and they were there until the house was inaugurated. The PDP were magnanimous to even give them a seat
a
in
lot
the
of
Senate.
people,
So
a lot of people will not agree with you, especially in the APC.
Yeah.
They won't agree
no,
with
they
you.
will, because they will. They witness the fact that.
But we are running out of time,
Okay,
gentlemen.
okay. So what is
How-
that the Senate has every power
to discipline
suspend
or sanction?
to suspend their member, Hunkuyi, and even any other member. But they have not wielded that power because they felt that this is our internal affair. And like I've said, we need this unity for the progress of Nigeria.
Okay, Abdullahi, in a very few minutes, what would be, I mean, talking as a lawyer, you know, with your training, what would be the best scenario tomorrow at that court? You know, when Justice Haliru sits over this matter tomorrow, with the hindsight of Kolawole's 28 ruling.
See, like I said earlier, we must understand that inasmuch a judge cannot just maybe by virtue of the fact that he read something in the newspaper and when he come to sit, he begin to act on it.
Okay.
No. Something must be presented before the court can act on it. Like I said earlier, what I expect tomorrow is for the #1 law officer, the Attorney General of the Federation, to inform Justice Haliru of the ruling of Justice Kolawole.
If he doesn't do it, can
If
someone
he
else
doesn't do
do
it,
Is
yes.
there any other person that
very
could
well,
do it?
Very well. Then the lawyer to the defendant, the lawyers to the defendant must have to inform that court that this is the ruling of your learned brother, although you have coordinate jurisdiction. But considering the problem we've been having, this court giving conflicting rulings and judgment in some cases, we just want you to be aware that there is a ruling of this court. If, I'm not saying, they may not terminate the charge completely, but let them pause for that matter at the Federal High Court to be determined so that we can arrest something that may likely come up tomorrow.
Okay, Ngozi, is there a possibility still of a political resolution of this matter?
Yeah, political resolution is the fact that
something, you know, something that is not very legalistic. Is there any way, you know, is there a possibility of that?
No, the possibility is, like I've said, that we politicians must come to accept the rule of law. The fact that it is a right of members of the parliament to elect their leaders. We started implementing it in 2011 when Tambuwal and Emeka Ihedioha emerged in the House of Reps as against Molekat Akande and the other person that PDP. Of course, you saw Tony Anene at the gallery that day, and the opposition party ganged up and brought Tambuwal, and he became a president. So I'm lending a hand to APC. They should bear with everybody. They should bear with Nigerians and allow Senator Ike Ekwuremadu, because that's the problem. If
no, but they said it's not the problem.
No.
Says
everybody must
problem.
agree. Everybody must agree.
says it's not the problem. The secretary to government, to the federal government, says that look, these are individual accusations. Let's not drag the entire Senate.
Sorry,
you have mentioned
if
about.
I may respond to that particular
yes,
statement of the secretary to the government of the Federation. In my own opinion, you cannot say it is their individual capacity.
No.
You know, they don't have
but
any.
Assuming they forged it, could it have been the Senate that say forge it?
No. It is not a part of their certificate. It is not part of their certificate for return. It is not part of their own personal credentials. Okay? It is not part of their local government of origin. And nobody should talk about this in relation to Salisu Buhari.
You are saying that
no,
that they cannot be tried in their capacity as individuals.
The Senate is on trial.
This Senate is on trial.
Okay, we'll leave it. Gentlemen, we'll leave it there. And I must thank you, Honorable Ngozi Ihuoma, Executive Secretary, Legislative Watch, for coming. Abdullahi Isezua Rahman, Senior Associate at Marble Partners. I want to thank you for coming.
Thank you very much.
And I want to thank you too for being with us on the program. And if you enjoyed it, let's do it again Tuesday night at 11 p.m. I am Obiora Ilo. Do have a wonderful week.